thank you to the organizers for inviting me. I'm honored, thrilled, and a bit overwhelmed to be able to present here to you my thoughts on privacy. As already mentioned, I deal primarily with internet governance, and privacy would be one of the issues that remain within my scope of interests. A general disclaimer, I will not try to explain what privacy in legal terms is. I have chosen a few challenges, a few issues that I believe fit within the discussion that we have been having. And those issues are the ones I want to raise. So it will not be a comprehensive explanation of how privacy works. That is not my aim. I'm just attempting to show you a few challenges that I hope will fuel the discussion that we have been having for the past few days. The scope. The idea that I have for this presentation is to present those challenges. I will start off with the legal tools, since being a lawyer, privacy to me is a human right, and I am looking for the legal tools to protect it. So I will start off with the legal tools for privacy protection. As already said, privacy to me is a human right. I will start with attempting to show you how privacy is perceived in the human rights catalog, and I will try to explain why it is an unenforceable human right. We do have privacy guarantees and they are unenforceable, and briefly I will try to explain or show you why that is the case. We do have a few regions, and those regions include Europe, where privacy may be relatively effectively protected. That has been the issue of our discussion here. You have been presented with examples of data protection in Europe that is more or less effective. I will not explain the whole European approach to privacy protection. Again, I will just attempt to pinpoint those challenges that I find interesting. Among those challenges, I would like to mention what I would like to call, and I will explain that term, peer-to-peer privacy. Now, the European Data Protection Directive foresees for certain exceptions from its application. Now, one of those exceptions is the so-called domestic or private use for private purposes of personal data. I will attempt to present what threats that exception brings and how ineffective the privacy protection and personal data protection in Europe therefore may be. I will then address another challenge that I see in the transatlantic collaboration or cooperation when it comes to data protection. I will present what the infamous safe harbor agreements are and why they are being perceived as ineffective. I will go on to conclusions. One of those conclusions that I will attempt to defend would be that we have an alternative. We have discussed alternatives yesterday. I believe that we have an alternative of either building so-called walled gardens of privacy. So we do have certain spaces, be it national spaces, that are safeguarded with electronic and legal walls within which privacy may be relatively effectively protected. Now, those walled gardens are against the whole idea of global transnational cyberspace. That is an alternative. Whether that is an alternative we wish to use, well, I would reconsider. And then eventually I'm hoping to arrive at a solution that reflects the current practice of companies and of states when it comes to extra-legal solutions to the privacy challenges. I will be referring to the Global Network Initiative with its efforts and with its successes when it comes to identifying the principles of privacy protection for companies operating on the global level. So that is the plan. That was satisfactorily brief. So that is the plan, and I will now try to meet those points that I have here presented. Obviously, privacy as a human right must be perceived in the context of the Universal Declaration of Human Rights that has been mentioned yesterday. Here you can see the lovely Eleanor Roosevelt holding up a version of the Declaration of Human Rights, a Spanish one, don't ask me one, but that's the Spanish version of the Declaration. There is no doubt that privacy as such is named as a human right. You have it clearly stated in Article 12. No one shall be subject to arbitrary interference with their privacy. It is right there next to family, home, or correspondence. But also the very same Universal Declaration of Human Rights in Article 29 already foresees for certain limitations. Now, the citation that you have in Article 29, paragraph 2 of the reasons why privacy may be limited or invaded has been repeated in numerous international law human rights documents. When privacy is to be limited, according to the Declaration and according to other international law treaties, that limitation must be firmly rooted in law. They may be introduced only if they are necessary for the due recognition and respect of the rights and freedoms of others, and if they are introduced to meet the just requirements of morality, public order, or the general welfare in a democratic society. Now, those terms may be perceived as broad. Much attention has been given to identifying what exactly they mean. Now, the Universal Declaration of Human Rights dates back to 1948. The world, having learned from the Second World War terrible experience, was willing to recognize certain human rights as invaluable to the humankind and put it in the form of declaration. Now, that declaration right now is perceived as an element of customary international law. If you look at it as an international law document, well, you're bound to fail because that declaration is non-binding. It took the world, almost 30 more years to introduce effectively a binding international law document that would protect the very same rights. Now, that internationally binding treaty is the International Covenant on Civil and Political Rights. If you look at this very brief description of its history, you will see that it was drafted in 1954, it was adopted by the UN in 1966, and it entered into force in 1976 because it was difficult. It was difficult to achieve a satisfactory compromise among the states, universally and globally, on the shape and the way of protecting human rights. Now, you might consider the Covenant a success. Here on the map, you can see, depicted in green, which countries have ratified the Convention. It is an international treaty. It is an enforceable international treaty, as you can see, almost ideally universally accepted. So it seems there really isn't a problem with international law. We do have a binding international law treaty that is allegedly effective worldwide. It took us some time, but we do have a consensus. Within the Covenant, again, the privacy protection is guaranteed in Article 17. Nobody shall be subject to arbitrary or unlawful interference with his privacy, and again, family, home, or correspondence. There is no limitation put within Article 17 on the protection of privacy, but the Human Rights Committee, and right now what is the Human Rights Council, have been helping us extensively to understand what privacy is, how it should be perceived, and how it ought to be protected. A document that you might find helpful when it comes to privacy protection in the global respect, with reference to the International Covenant, would be an article, document dating back to 1988, a general comment number 16 on Article 17 on the right to privacy. What are we told within that document? Just summarizing it briefly. One element that I find of particular importance, it's not just the states are to refrain from invading your privacy. They do have a positive obligation to protect it. It is a global standard confirmed by the committee, by the council presently. So it's not just for the states to refrain from surveillance, it is for them to effectively protect you against the surveillance originating from third parties or other sources, right? This is something that seems crucial to our discussions here. So even if a foreign state is attempting to invade your privacy, your country, your state, your authorities have a positive obligation to defend you effectively according to the general comment. What I find lovely is that all the way back in ancient history, 1988, the comment clearly states that any surveillance should be prohibited. We are discussing here how much surveillance is all right and what are the limits. It should generally be prohibited. Naturally, there are other acts of international law that attempt to define the exception to that rule, but we do have a rule that tells us surveillance is wrong. The committee also defines when limitations upon your privacy may be introduced. And as you can see, they always have to be based on law, but they should be introduced on a case-by-case basis. So you need to depict within the law when privacy may be invaded, and when that general clause foreseen by the law is to be enforced, that enforcing must be done on a case-by-case basis. So that authority needs to look at a particular case and then decide, yes, we will violate the privacy of that individual for reasons mentioned above. As you could see, Article 17 requires the state not only to introduce privacy invasions through law, but also to avoid arbitrary interventions. Just basing the intervention on law is not enough. That intervention must not, we can see in the comment, be arbitrary. That means that even if you are operating on case-by-case basis, even if you are operating on a rule of law, on a particular description that is there in law, that intervention must be reasonable in particular circumstances. So your privacy, it seems, is broadly, comprehensively protected on the global level. You could see all the green states. Everyone is supposed to be enforcing those recommendations, those comments. Why doesn't it work? Well, the answer is surprisingly simple. I could give you a long answer, but I won't. It's because of politics. Now, the committee, or presently the council, has been criticized for numerous years for not doing what it's supposed to. The council is there to protect you through various mechanisms, individual complaints, state complaints, verifying the state practice, to protect you, the individual, from human rights violations, not just privacy, but any other violation of your human right, is supposed to be noticed and deleted, avoided through the instruments available to the Human Rights Council. It's not working because of political influence. Now, within one of articles, you can see here one presented by Reuters, it's being said that the Council has fallen under the control, I'm just quoting, of Islamic and Arabic states that are supported by strong players on the international arena, such as China, such as Russia, who have a different perception of human rights and privacy, freedom of speech protection, etc. So we do have a mechanism in international law to protect your privacy, very strict, very rigid, directly applicable towards states, and it's not working because of politics. Is there any hope? Now, obviously, this presentation is about giving you hope, so I will arrive at certain conclusions at the end. Is there any hope for the international law regime? Well, there has been that idea of the World Court of Human Rights. Like we have in Europe the European Court of Human Rights, there was an idea to put states on trial, not individuals, as is the case with the International Criminal Court, but states. If you, dear state authorities, are violating the rights of your individuals, you will be forced to pay. You will be forced to refrain from violating those rights and pay. The World Court of Human Rights, just as we have the European Court of Human Rights. The idea has been there from 1947. 1947, 1940s was the time when people really appreciated human rights due to the very violent history. In 1947, the idea of a World Court of Human Rights was introduced. It was supposed to work just like the European Court of Human Rights. Because of the 60th anniversary of the Universal Declaration, that idea was revived. There was actually a draft statute of a World Court of Human Rights presented by academics for academic purposes. As you could see here, those very same academics that proposed the statute clearly identified the idea to be more or less utopian. It's not enforceable in the current political, social situation to have a court that would tell the states how to protect individual privacy. Therefore, what we have in Europe should be considered relatively unique. There is no effective global protection of individual privacy, although the guarantees and the compromise and the consensus, if you will, are there. In Europe, we're a bit more lucky. We do have effective, more or less effective privacy protection. Since I am dealing with human rights, I will follow on that path. We obviously in Europe have the Convention on Human Rights, European Convention on Human Rights. You have the full name of the convention here on the slide. It was drafted in 1915 and in late 1940s. It was accepted, it was enforced in 1953. It was one of the milestones upon which the International Covenant was built. In Article 8, again, the word private life appears, so you do have the guarantee for your privacy. And in paragraph 2, the famous paragraph 2, you have certain limitations which may be laid upon you when your privacy is to be interfered with or invaded. Article 8, as is the whole of the European Convention, is accompanied by rich jurisprudence. The European Court of Human Rights has done a really good job in defining what privacy is, although if you were to search for the definition of privacy, you would never find it. The court is very particular about not giving us a definition, and at the same time, it's giving you guidelines what privacy is and what privacy isn't. So we do have rich jurisprudence coming from the European Court of Human Rights telling you what privacy is. To my eyes, that would be one of the more effective ways of protecting your privacy through the convention. And since I'm to speak about the challenges, I'll just leave it at that, right? That's a success. That's something we can be proud of. The European communities have also introduced the protection of private life within the Charter of Fundamental Rights of the European Union. Now, that document, the enforceability of that document, has been subject to discussion. Well, first, it was introduced in Nice in 2000, and nobody really knew what it was. It was sort of a soft law document. Then eventually, with the Lisbon Treaty in 2009, it was enforced as an element, it was perceived as an element of the European law. Whether it actually works, whether it's actually effective may be questioned, especially since Britain, Poland, and the Czech Republic have opted out of the protocol. There is a protocol that is saying we will not respect our actions being judged according to the rules set out in the Charter. Why I am presenting this slide is the fact that you can see here how in European law privacy is being perceived. It's being perceived through two lenses. The one would be a traditional protection of privacy, while the other would be the protection of personal data. The European Union kind of had to stretch to, on one hand, respect the protection of privacy as enshrined in the European Convention, and on the other hand, to relate to the rich legal background it had in personal data protection. So the Charter kind of combines the two elements we have in European law for privacy protection. On one hand, it would be your private life, and on the other, it would be your personal data. Now, personal data protection is probably the most effective tool for protecting your privacy in European law, in community law, in what used to be a community law. Now, that data protection is being enforced primarily through the application of the Personal Data Directive, which full name you can see here on the slide. As already mentioned, I'm not going to go into all the details and the definition of controllers and data subjects, etc., etc. We have done some of that. I want to pinpoint two challenges that come with the directive. That is my aim. The first one that I believe might be of interest would be the exception that is foreseen in Article 3 of the directive. The directive is to be applied to state authorities, to companies, to businesses, to private persons who are conducting business activities. The directive shall not apply to the processing of personal data by a natural person in the course of a purely personal or household activity. What was the point? Well, the point was that if you have a really nice filofax like that one, not many people do, I think, but I still have one. So if you have something like that, that is a combination of personal data. You have names, telephone numbers, birthdays, etc. Sometimes you have pictures. So that would be a compilation of personal data. If you were a company, you would have to have that organized according to the directive or national law standards. You would probably have to make that known to the National Data Protection Authority. If you're a private person and you are processing that personal data for purely personal reasons, you don't have to do that. Now, that is reasonable, right? If you have a name and a phone number slapped onto your refrigerator door, it would be silly to be processing personal data and having to adhere to the directive principles. The exception is, it seems, rational. But then we arrived at personal activity online. What is purely personal activity when conducted online? Would that be your social network? So if I am sharing that phone number and name of a friend with my roommate, I'm slapping it on the refrigerator door, that is purely personal activity. If I am slapping that on my Facebook wall, is that a purely personal activity? Should the criteria be the possibility to control the number of recipients of that message. So if you are disclosing it just to your friends on Facebook, that would be purely personal activity. If you're making that information public, well, would that then fall outside of that scope? What if you have 3,000 friends on Facebook? Is that still purely personal activity? You are controlling the scope of people who receive that personal information, but is that still purely personal activity? And what is more, is that really the reason that the exception was introduced, right? So what is a purely personal activity online would be my question. Another interesting aspect of purely personal activity would be your private web pages, not just social networks, but websites. When you would publish information of bad doctors, bad lawyers. I'm sure there are no websites of bad computer scientists, but there are those websites that are considered defamatory, where you would have names and numbers of people who are not doing their job all that well. Is that purely personal activity? I would say no, you're making that information public. But in Poland, we do have a case where the administrative Supreme Court said, yes, if it's your personal web page, you are exercising a purely personal activity, right? So opinions may differ on what a purely personal activity online is. I would say that the criteria for delimiting personal activity online would be the availability of data. If you can control who has access to your data, that would make it personal. I would say it would also depend on the character of your network. If it's a closed network, if it's an intranet, if it's a network where only limited amount of recipients can have access to your data, that might be considered, depending on a case specific, as a purely personal activity. But that question is not as easy to answer as it might seem. Now, I would like to raise the issue of peer-to-peer privacy. So I'm not speaking about privacy invasions by authorities. I'm not speaking about privacy invasions by companies. I'm speaking about the privacy, your privacy, that is being disclosed by your friends. Now, it comes down, right now, I would say, most of all, to face recognition software. To my eyes, it started with Kulesza that allowed you to identify your friends with appropriate software. But that wasn't really that much of a challenge, because you could mark the faces of your friends within your own resources, possibly with resources, online resources that were shared with you. And then Facebook kind of broke the ice and introduced face recognition as an automatic opt-in. It was just introduced as an app. If you had a Facebook account, you would be encouraged to tag your friends, and you would have certain suggestions as on what other pictures that you had access to, those friends may be found. Facebook was really scolded for having introduced it. They were the first guys who just did it, and it didn't really work out. I believe they are right now withdrawing that application as a default opt-in possibility for their users. Now here you can, in my perception, quite well see the competition, the privacy protection competition that is going on between Facebook and Google+, that is Google+. They have also introduced face recognition. That is actually the designer of the face recognition software for Google+. And there it is an opt-out option. So if you have a Google+ account, you may opt into face recognition with your consent, and then you will be doing the same things. But as a default, you're not part of the face recognition software being introduced. It's not about Facebook, and it's not about Google in this case. It's about your friends tagging you in pictures. Now, the current guidelines that are introduced through recommendations, not originating directly from law, tell you that, well, if you have consent of the person you're tagging, then it's okay. The social network, the website, should allow you to ask for consent. If you want to tag someone in picture, they should be contacted and asked, is that okay if I tag you in that picture? If that is the case, it's not so bad. But not that many websites ask for that consent. So if you are being tagged in a picture and you can do nothing about it, that would be a privacy violation. If the service is located outside of Europe or outside of your country, it might be difficult for you to enforce protection against such a privacy violation. It's not something that's being done by the company. It's something that's being done by your school friends sitting right there in your neighborhood or somewhere in the neighborhood of your house. So that would be a privacy invasion that's being introduced by an individual. It goes on. Face recognition software may be deployed, and Google stated it's technically possible with applications such as Google Goggles. For now, you can take a picture of the Eiffel Tower, upload it, and you will be informed what that monument that you're standing in front of is. It's technically possible to take a picture of a stranger that you're waiting for a bus with, a really nice stranger possibly, upload it online, and with face recognition software have identity of that person recognized. It's technically possible. Google, being privacy friendly as they claim, have not introduced that option as your possibility within the Google Goggles application. It goes on. The personal data that is being enabled about you by your friends is not just your face. It's not just the information on your name, school, birth date, etc., etc. It goes on to the so-called Geo Localization Data. So the information on your whereabouts in a particular place and time. Now, with the, again, Facebook Places application or capability, you are able to inform your friends where you are. Now, you know that the point is to be able to meet your friends that are in the neighborhood. You're kind of sending out this message, I'm here, is there anyone else in the neighborhood? Now, the fact is that you are able to provide others with information on your personal whereabouts that are, well, that is the question, that may be considered as personal data. Now, the Article 29 Working Party that's working on the interpretation of the Personal Data Directive has provided us with guidelines on the geolocalization data. And they have clearly stated, we are not touching upon information being provided by individual users. It's not clear whether you may consider that information being provided about you as personal data protected within the directive, and therefore also adds the exception from Article 3. Even if that was personal data, would that be personal use of that personal data? I would say that all of that information scattered around the network by your friends is getting easier to use with the social semantic web that I am sure I do not need to explain in a room full of computer scientists. It is forever easier to gather information located in different parts of the network and create, for your own private purposes, complete profiles. Now, the Friend of a Friend project is just one of the possibilities to employ the social semantic web for your purposes. The aim of that project is exactly as I have defined it. So you're gathering information about a particular person from different publicly available sources. If they have a website, you have their name, you have their location, possibly the name of their spouse or the picture of their child. If they have a LinkedIn account, you're gathering information about the schools they went to or the places where they have worked. If they have a Facebook account, you're gathering information about their friends. It's all publicly available. It has been provided either by the person themselves, which is of less worry, or by other people for them, which is the challenge that I'm trying to address. So the Friend of a Friend project allows you to use that personal information and combine it, profile it for your own private purposes. Now, there have actually been even an IPI attempts to use that social graph. Now, Google is right now withdrawing from that project. That project is being cancelled. But that was exactly a practical application of the social semantic web. So you would have all the private information being gathered through an API for your website. So the social semantic web is being fueled with private information provided by private individuals. I thought it was just me that was getting so warm because I'm getting worked up. All right. It's not just me, you're saying. No. That's good. That's a relief.
Well, and those screens are hot, so we wanted to.
Thank you. Thank you.
No, I think we're all a little more.
All right. So the social semantic web is being fueled with information not just coming from the individual, but coming from other sources. To me, the peer-to-peer privacy dilemma, which I see as one of the biggest challenges, I will address the second biggest challenge in a second, originates from new categories of personal data. You have geolocalization data enabled by the user or by their friends. I'm here with Jen in this nice cafe in New York, for example, that we don't know how to qualify, really. You have new tools originating from the possibilities offered by the network that enable you to do detailed personal profiling for your own private purposes. There's practically no anonymity online, and that is not a new statement. I have it here in red because I think it's important, but I think we covered that. There's no anonymity online. The electronic data is durable. So whether there's a right to be forgotten as introduced by, well, as proposed by the new regulation, well, that would be doubtful whether that is a right that can be enforced. Jonathan Citrain puts it shortly, but very accurately, when he identifies the peer-to-peer privacy dilemma as a privacy 2.0 dilemma. He's telling us that it's not the government and it's not the companies that are surveilling us that are our biggest threat. It's our friends, or it's the tourists. If you go out there and do High Street in Oxford, you will get photographed by at least 5 people if you stay there long enough. If your face is being recognized and they have tagged that picture when it was taken and where it was taken, well, people will know that you've been to Oxford. You haven't actually been to the Caribbean or something. You've been to Oxford and you stayed at the summer school probably. So it's not the privacy invasions that originate from state authorities that are the threat. They are a threat. But there is an comparable threat originating from the army of photographers, as Citrain so nicely puts it. You could try to sue your friends that have tagged you on Facebook. It's not the nicest thing to do, but I'm speaking here about legal tools, right? So you could try to sue them. Forget Facebook, forget Google, forget those companies that are residing outside of Europe that you have not really effective legal tools to sue. You could sue your friends. Now, privacy is a personal right. Personal rights are recognized within national civil law systems. They are not defined as a category, but they are usually an open catalog. So you would have your health, you would have your dignity, you would have your reputation as elements of the personal rights catalog. There is little doubt that privacy is a personal right. Now, within the European doctrine of civil law, privacy is often perceived through, originating from the German doctrine, the theory of spheres. So every individual is perceived to have at least 3, but I will show you there can be more, at least 3 spheres surrounding them. The one that's most important to you, that's closest to you, would be your intimate sphere. And that would be your thoughts and feelings that you decide to share with few, if any. The other the wider sphere would be your privacy sphere. And that would be the information that you are not willing to share with the public. However, if you do decide to share it with the public, it is transported into the public sphere where no protection is offered. Now, it seems really simple. Whenever you're acting in your public capacity, like I am right now, we all have a public function. We're students, we're lecturers sometimes. We do have a public sphere. If you're in the public sphere, you have no protection. If you are outside of the public sphere, it is your consent that transfers particular information about you from privacy from the private sphere to the public sphere. Simple, isn't it? Right? If something is private, you can decide to make it public. If something is public, you have no protection. It seems simple. When you try to apply it and when you go to court and it's being analyzed on a case-by-case basis, personal right protection gets difficult and very costly. So if you decide to protect your privacy as a personal right, that might be a serious legal challenge. I cannot guarantee it will be effective. Now, just to make it a bit more complicated, the German doctrine has also elaborated a few more spheres if you wish to make that simple scheme a bit more complicated. So you would have your public sphere, and then you would have your social sphere, where limited protection would be awarded, where the social sphere would be something you would share with your friends. Not with everyone, just with your friends, with a group. Then you would have your privacy sphere, where only your closest friends would be included. So something you would tell your spouse or your mom or your sister, but not all the people that you know. Eventually you would have the intimate sphere with information that are most valuable to you and that you would share with few people, if any. And then some say there is a secret sphere with the information that you would never share with anyone. So as you can see, even if I try to make it really simple with really nice colors, it's difficult to define where the privacy delimitation is. So if you decide to protect your privacy as a personal right, you might have quite a practical problem. The second challenge that I promised to tell you a little bit about, that will be the transatlantic challenge, and I will try to make this brief. Again, the directive, just a reference for you to look at, not something that we should read in detail. Privacy is perceived, or personal data protection rather, is perceived in the United States a bit different than it is in the EU. Personal data are more a commercial commodity than an element of a human right of privacy. You already know that the human right of privacy at a global level may not be effectively enforced, so that is not something we should look at. Now, the directive requires the member states, if they wish to transfer the data to any third parties, to make sure that those third parties ensure an adequate level of protection. So if data is to be transferred from a member state to a non-member state, that non-member state has to ensure an adequate level of protection. Who assesses whether the level is adequate? Well, it's the Commission. If the Commission finds that the level of protection outside member states is not adequate, you cannot transfer data there. That is the briefest I can do in attempting to explain why we have safe harbor agreements. Now, since in the US, data protection is perceived differently, and the US did want to have a big chunk of European data, safe harbor agreements were introduced. Now, this is an initiative that was coordinated by the US Department of Commerce. As you can see here, it was 1998 that the document was negotiated. The safe harbor privacy principles are a set of principles that must be accepted by US companies if they wish to work with, if they wish to process data originating from the member states. The system is not a legally enforceable one. If you are a US company and you wish to use personal data protected by EU law, you must adhere to one of the sets of principles that are being coordinated by numerous self-regulating programs. So if you are a company and you want European data, you make a claim that you are respecting the sanctions. If you adhere to the safe harbor principles, you are making a plea that you will meet the 7 basic aims of the directive, as identified in the directive and in the safe harbor itself. Just to briefly go on, as already mentioned, the safe harbor privacy principles are not an act of law. It's not a treaty, it's a plea, it's a self-regulation mechanism. The mechanism that's behind it is for the Federal Trade Commission to be able to recognize failure to meet the principles as an act of unfair or deceptive trade practice. So it's not a violation of EU law. If you adhere to the principles and you break that promise, you may be considered as having committed an act of unfair or discriminative trade practice. There is the Department of Trade, the Federal Trade Commission, that is authorized to pursue those violations. What is more, if a company does have a headquarters in Europe, the European legislation may also apply, but basically it's there for the US-based companies to be recognized. The safe harbor principles, this is just an outtake of the review, has been scrutinized and it has been criticized thoroughly. The Federal Trade Commission is not doing enough, the report said. There were at least 2 reports provided assessing how the safe harbor agreements work. One was in 2004, it was provided by the Commission, and the Commission said that the Federal Trade Commission should look more closely into how the principles are being obeyed, what the companies are actually doing when they are claiming they are respecting the principles. The report also said that the voluntary character of the principles is not doing them all that good because well, the companies claim they are respecting them and they are not really respecting them as they should. And then in 2008, there was an independent review that said that the safe harbor compliance and recognition, the low level of compliance and recognition is a threat to consumer privacy. So that mechanism is not working as well as it should. This brings me to the wider look at the problem. You can see here, I really like this map, a really nice map that's been provided by Amnesty International, by Privacy International, and they have analyzed national laws that deal with privacy protection. In blue here, you can see the states that have introduced comprehensive data protection laws. So basically, if you are to export your data to one of those countries, you would have a similar level of protection. Those blue states are not the problem. The ones marked in white would be the one that you have no data protection laws. So you can see the US proudly stands out in that map. We do have safe harbor, but it's not a data protection law, and it's not really an effective mechanism, as you could see. Just more or less, it's half of the world that doesn't have data protection laws that are effective. The red ones would be the ones that have pending regulation. So there are certain efforts to introduce regulation, but it's not being introduced yet. And this map is relatively fresh because it comes from February 2011. So your data is protected on the European level of personal data protection in, well, more or less, so it's less than half of the states in the world. The other half really isn't that much into privacy and data protection as we are in Europe. Why is it? Why do we have that divergence? Now, this will be very graphic. I hope you're ready for this. Why do we have that divergence? Well, the law in the world looks more or less like this. The law is designed territorially. We have territorial states. There is no going around it. Laws are made for certain territories and their residents. Now, cyberspace looks a bit different. There are different ways of presenting, of showing what the cyberspace architecture is. I really like this one. And you can see all the monopolists here on the map with, you know, the Polish telecommunication being the gate out of Poland, for example. I really love that. So the cyberspace looks more or less like that. It's just an entanglement of electric nodes. If you try to introduce nationally acceptable privacy standards for cyberspace, it's not possible because the two just don't go together. You have national laws and you have the transboundary cyberspace. If we were to introduce national laws in cyberspace, we would have to delimit it. There have been attempts. Yesterday, we heard about a recent alleged Iranian attempt to delimit national cyberspace. Now, there have been claims made that Iran is actually switching off the internet in the whole of the country. China is quite effective in protecting its territorial space online. But that seems for now to be the exception. There have been certain claims made by European authorities a few years back that we would have a European cyberspace. So you would have electronic barriers with small gates, with narrow gates, that would enable data to go in and out. That would make the data in the European territory safe. Whether that would be good for the network, well, I beg to differ. I would assume that creating national borders for cyberspace would be against the idea of the cyberspace itself, which is supposed to be transboundary and international. So what are we to do? Introducing national barriers in cyberspace, building walled gardens of privacy within national spaces seems irrational. What are the solutions that we might look into? You could try to use the services of certain companies. There are companies out there that have analyzed the problem more thoroughly than I have here. And they know that every national legal system offers you certain tools. Sometimes there are extra legal tools available to you in certain jurisdictions. You can ask a service like Reputation Defender, for example, to watch out for your privacy and what follows for your reputation for you. So if there is information about you that you don't like, you will just ask them and pay them to have that information removed or altered. It's none of your concern how they do it, whether they use solely the legal methods or whether they will be using some extra legal methods. It's not your concern. This is a good solution for an individual. If you want to protect your privacy, all right, you can use services like that. We would rather need a universal solution. What is right now the case is that you do have walled gardens of privacy, but they are not walled by the states. They are rather contained within particular online communities. So you would have your privacy guarantees, for example, for Facebook. You would have a different privacy policy for Google+, for example. And it would be the users that would actually decide what model of privacy they like. What model of privacy is suitable. I would say that this picture pretty well depicts the current state of privacy protection. You have different services that offer you different levels of protection. If we were seeking an international solution, a global solution since we already know that international doesn't give us one? Where are we to go? Well, there's one initiative that I find particularly interest-worthy. That would be the Global Network Initiative. Now, the Global Network Initiative is a collaboration of activists, but also of companies who are looking into introducing principles for privacy protection that are satisfactory to the users, that are coherent with international law. They are based on the recommendations for businesses provided by the UN Commissioner for Human Rights. And they are looking into the practice. So the Global Network Initiative is there to analyze the principles that have been introduced by certain companies, like Google, for example, and are there to provide general principles of privacy protection enforceable worldwide. Now, the recommendation that the Global Network Initiative gives us would be, for example, a risk assessment. If you are to conduct your business in a country where you know that data may be exploited, first of all, you must aim to minimize the risk of data exploitation. Second of all, you should provide a risk assessment. You should ask legal and technical specialists to tell you what are the risks for abuse of personal data that you have stored in that country. I would find that initiative to have a lot of potential when it comes to elaborating a global privacy standard for online communications. It's not a legal tool. It's a co-regulation or self-regulation, if you will, tool. But I do believe that that is what we have to do. We have to look at the practice, and from the practice, attempt to identify general principles. Summing up, I would say, being an optimist and being a utopian optimist, there is little chance for a binding treaty on international privacy. We do have treaties and they just don't work. I would say that we do have a good chance of a common business practice, just as introduced by the Global Network Initiative. What we could do would be to introduce walled gardens based on national legal regulations, but I would believe that that would be contradictory to the global nature of the cyberspace itself. And that's that. Thank you very much. If there are any questions, I would be happy to answer.
I have a question. You just say you want international regulations, international laws to be okay. How do you really enforce that laws? I mean, how do you actually force a country to implement all that stuff? I mean, if China says no, they say no, and nobody will attack them, ever.
Right. Well, if your question is general, then I would generally say sanctions, right? International law does foresee sanctions, which are not introduced often, which are not introduced eagerly. But if you want to force a state to conform to a certain way of behaving, you can either use economic sanctions or military sanctions, as so rarely happens, right? So international law does have a way of coercing states to do what they are not really willing to do. That would be diplomatic pressure, for example. That is something that is being used to push China into more human rights friendly approach, right? There is economic collaboration and there is diplomatic pressure. Those are the instruments that are available more commonly in international law. So international law does have instruments to enforce certain obligations upon states. Whether those instruments are being deployed, that is a different question. And my point was that they are not being deployed when it comes to privacy or freedom of speech protection. They are being deployed when it comes to trade practices, etc., right? So it depends what is the activity of the state that you want to see happening. I hope that answers your question, Marnus.
Well, thank you very much for your presentation. I just have a couple of questions. What option did Estonia, for example, had in case of cyber attack? I mean, could they prosecute, take Russia to some court, for example? And do you see all those as a privacy invasion as well? And similarly, for in case of Iran, what option they had? Because there have been claims made by US that yes, the Stuxnet was actually backed by them. So again, I would like to also hear your comment on this new law, which US says that if their critical infrastructure is being attacked by another territory, then they could really reply against those attacks by using a physical space as well.
Yeah, now that would be, as you probably know, some of my favorite questions. I'm worried that they're not as closely bound to privacy protection, but with everyone in the room agreeing, I would love to answer those. Yeah, is that of interest to all of other parts?
Sure.
Relatively, all right. So I would say that with Estonia, the case would be stronger because Estonians were able to identify the attacks in 2007 that took down the Estonian infrastructure for over 14 days as originating from Russia. So they have informed the Russians. They said, look, there are attacks originating from your territory. And the Russians didn't do that much about those attacks originating. To my mind, there is the possibility to employ the concept of due diligence. Now, due diligence in international law obliges the states to take all possible reasonable measures to protect others from harm originating from their territory. It's not so much about privacy as it is about transboundary damage prevention or protection from such damage. So if you do know that there is damage originating from your territory and you do nothing about it, to me that would be a failure in providing due diligence. I would say that due diligence may be considered a principle of international law. Now, a violation of that principle that may be derived, for example, from the United Nations Charter, Article 2, Paragraph 4, may be considered a violation of international law. If that is the case, you have an international law dispute. And if that is the case, and that dispute may not be settled amicably, and I would say that the states would not be willing to amicably settle that dispute, you may go to the International Court of Justice, for example. Right? So just giving you a relatively simple answer. I believe that in the Estonia case, the attribution of those attacks to Russian territory and Russia not preventing those attacks might be easier than in the case of the Stuxnet worm attack.
And then again, the question would be, how could they attribute those attacks? Because even Russian asked other Russian fellows in other countries, like in US, to launch attack into Estonia at the same point in time. So the attacks are coming from all over the world. And of course, Russia was trying to convince the other Russians and other people around the globe to attack Estonian infrastructure. So, to attribute those attacks again probably would be a challenging for Estonia.
I would be thrilled to see that case before an international tribunal. I think you would be too, since you are in the technical expertise of attributing cyber attacks. So I believe it would come to a particular case being examined by the court. It would come to forensic evidence, probably. I believe that Russia making a claim, yes, the attacks were originated from our territory, but they were originated by private individuals, would make Estonian case stronger. Because there were claims made, yes, the attacks there is actually this young man that's in this political organization that is located in Russia who's made several claims saying, yeah, it was our organization, we kind of, are here around Kremlin, we originated and So I would say that would make Estonia's claims stronger, right? There is an organization that is saying we've done that. States do not hold responsibility for private persons as a general principle. But there is also a principle, as already mentioned, of due diligence. So if you know that there are individuals who are causing harm to foreign states, you are supposed to introduce certain preventive measures. We don't have a due diligence standard for cyberspace as such. I would argue that one might be identified if you examine the existing work of the International Law Commission when it comes to environmental law, for example, or international liability for transboundary harm. So with the Estonian case, I would say that might be considered a stronger case. With the Stuxnet worm attacks, that would be more difficult. I have read in the New York Times of claims being made by American authorities indirectly claiming support. Yeah. And that is all that I have been able to identify. So making an attribution of that attack to a particular territory, or for that matter, a state, to my mind would be more difficult. Now you are the expert when it comes to the technical expertise.
Yes.
Right. So, we must keep in mind that the Stuxnet worm attack was the most elaborate one in history until its day. So that was a new situation that, when confronted with the International Court of Justice, would be more difficult for it to identify. So attribution would be crucial, and attribution not to state authorities, because that would probably be nearly to impossible.
I know someone trying to attribute, he had the sample of the code, and what they're trying to do is to attribute the coding style of the developer. I mean, the way the different developer would write a code, attributing to some geographical location or map. The people in that particular region would like the code in certain style, you know. But I don't know, that probably would be admissible into the code.
Well, if I were the judge of the International Court of Justice, which obviously is an option somewhere, right? So I don't know if that would be something that would convince me, right? That is the style of writing in a certain part of country, especially with the global transboundary cyberspace. You might be successful. I'm not the judge yet, as already said, but you might need stronger evidence, right? So, and I would rely on the due diligence standard rather than attribution of state actions, because that would be really difficult, right? I don't think that answers the whole of your question, but I think it answers the gist of it, right? So thank you.
It's a fascinating talk. Thank you very much indeed.
Well, thank you.
I just had some observations on different parts. Firstly, on this question of attribution, I saw a couple of years ago, the BBC did track down the Russian nationalist hacker who did claim to do this, and you know, there he was in his bedroom saying, "Yes, it was me.
Yeah.
You know, I got a botnet, and that's how I did it." Ho ho ho. And I agree with your remarks that it would be difficult to do much about that. Although I think it's worrying that several states are now calling for, as it were, the re-engineering of the future internet to make attribution more possible, which I think is fundamentally misguided for technical reasons. But also they're calling for the creation of some kind of aggravated cyber terrorism or offence. Mm-hmm. And I think one has to be very careful what one wishes for there, because that would mean, for example, that if that created a duty on a state to restrain that kind of activity within their own borders, then, for example, if you had civil society protests deciding to blockade some website or something, or mount a CISPA-type protest, that could become, you know, a major act of cyber terrorism, which would throw people in jail potentially, you know, for decades. So that seems to be quite a worrying way that argument could be diverted. On the question of attribution, one option I haven't really seen discussed is, you may have read quite recently, there was a case of market competition abuse by a big pharmaceutical company, and some whistleblowers basically blew the whistle on that, and under some treaty or US law, I'm not sure which one, they got an enormous payout, hundreds of millions of dollars they're due to get. So if you imagine the situation of somebody working in some state sort of sponsored cyber weaponry laboratory that is supposed not to exist under some treaty, well, if there was an international treaty which created a bounty of several $100 million, then even effectively you'd be asking citizens of one country to sort of rat out their own country's military strategy. For a few $100 million, that would be a serious deterrent, which would make such a treaty potentially enforceable, I would say. But I don't often see that possibility discussed. On the question of Genie, I'm a bit more jaundiced about Genie because it's had such corporate involvement from the get-go, and I've seen inside Microsoft how Genie is basically a joke. Nobody takes it seriously. It doesn't have any restraint on what corporates really do. Perhaps that's just my cynicism, but I find those sort of self-regulatory initiatives with corporate involvement always going to be very suspect. I think it's worth re-emphasising on the safe harbour reports that you mentioned, both of the 2004 and the 2008 Kulesza study. They were only really dealing with the paperwork of safe harbour. They didn't even investigate what was really going on in terms of the substantive practices of safe harbour companies, nor did they look at the difficulty of actually exercising rights under safe harbour. So even at the paper level, safe harbour is sort of a basket case.
Bad.
Then the question of walled gardens. I'm more sanguine about the possibility for walled gardens. I mean, in this sense that if I set up a virtual private network with somebody in Brazil and somebody in the US and somebody in Estonia, and I want to share information privately within that, well, that works quite well. what doesn't work so well is when people sort of contract, or maybe states also contract with each other to share information on really hard and fast terms. And the problem seems to be an imbalance of bargaining power in contractual negotiation. So, for example, if you have an individual or indeed a small country deciding to share its data with a larger country, when you're trying to negotiate, as it were, the get-out clauses that another stronger power, a stronger party might use and abuse, it's very difficult to sort of nail down an agreement, a simple agreement, which will be enforceable, to make those walled gardens enforceable. So in a sense, the problem with walled gardens is not a technical problem, I think. It's more a legal imbalance of power problem.
Yes.
And lastly, I think it's interesting when one's thinking about peer-to-peer privacy, and I'd very much like to know if this has occurred to you, is a couple of years ago, Google, in fact, YouTube, was convicted of a criminal data protection offence in Italy. And the case concerned somebody who had posted onto YouTube a video of a child with Down syndrome for the purpose of ridiculing that child.
Mm-hmm.
And really rather offensively, that became one of the most popular YouTube videos in the country for a while. Now, sort of Google Yahoo's position was that they took this down promptly once they were notified. And in fact, it became something of a cause célèbre because some Google executives were given this criminal conviction. And I think the case is still being appealed. And so Google's PR made a great hype about this, about it was all about prior restraint. And it's absurd of this Italian court to think that anyone was going to be able to scrutinize every video that's posted online. However, I did happen to see, or happen to be able to get access to, a gloss of the actual Italian verdict, which came out sometime later. And when you actually study the verdict, the reasoning of the judges was on a quite different basis. It wasn't, in fact, calling for prior restraint at all. What they said was that YouTube had been deficient in not warning its users that they were effectively taking on the responsibilities of co-controllers. And I wondered if you thought about that in relation to peer-to-peer privacy.
All right, those are all very interesting comments, and I will try to make as brief of responses as I can, but let me know if I fail or will be too short. First, on the walled gardens as a political problem or a legal problem. To my eyes, we do have particular, be it international private law or mutual legal assistance treaties in place. I was told by the people who are competent in the technical aspect of the internet that the challenge would be to actually limit the cyberspace. As already said, well, please verify that statement, but I'm not that technically aware, so that's what I'm relying upon. The Chinese are successful when it comes to delimiting their space, but if you were to limit each national space, that would be difficult. Now, the most interesting proposal I have heard would be to delimit the cyberspace according to the CCTLDs. Now, that's a lovely one, right? So everything that has .pl would be in Polish jurisdiction. It's a lovely one. But, well, speaking of more practical possibilities, I was told that it's technically difficult.
So
I'm
not
right.
sure I understand this at all, because if one's talking about sort of TLDs, or should we say the public internet, well, obviously there's no question restricting any information on the public internet. Implicitly, we must be talking about some system where there's confidentiality of communications and access control. So this discussion seems to be at a totally different level. I don't understand it.
I'm thinking about filtering. So I'm thinking that if something is illegal in the Polish cyberspace, it would be filtered out of the Polish territory. That's what I'm thinking. And I'm thinking that if that was to be introduced, it would be A, difficult, B, costly. That's a discussion we're having right now in Poland about filtering.
Isn't filtering conceptually quite a different problem from the question of actually restricting information within some closed group?
I would say that restricting information within a closed group would mean not allowing undesired information within that group. That's my understanding of it. So if I have the Polish cyberspace, I am doing my best to restrict information that is contrary to the Polish legal system from coming into that space,
yes,
right?
But the restricting information from coming into a space is quite a different technical problem from stopping information escaping from some space.
Right, but what I understood from the electronic European Schengen Agreement project would be that you would have two-way gates, right? So on one hand, you would be filtering everything coming into the European cyberspace, keeping everything that's illegal in Europe out. I would imagine you would have different levels of filtering, because if something is illegal according to EU law, it would be filtered on the Schengen borders. And then if it was illegal according to national regulations, you would have that second step. I can't really technically imagine that, but that would be the case. And those gates would stop unwanted information from coming in, and would also serve the purpose of not allowing certain information to get out, like personal data.
Honestly, the technical situations are totally incommensurable. I mean, you couldn't even get off the ground floor discussing those two agendas in the same way.
So that would be different applications, you're saying?
It's completely different from the problem of like stopping information coming in. Completely different. You couldn't even talk
Well,
about
that was the idea of the electronic Schengen agreement. That's what I understood from it, that you would on one hand stop information from coming in that's illegal, and on the other hand, you would allow certain information to get out only if it was...
I mean, the Schengen Agreement is, as I understand, I mean, if we talk about the original Schengen Agreement, that's really a way of sharing police records about immigration controls to certain border authorities. Now, if that's becoming used to mean, as it were, a sort of almost Great Wall of China type system, well, I wasn't aware of that, but that's whoever is talking about it like that, I would suggest really doesn't know what they're talking about.
Right. Well, I think that concept, I believe that is a common understanding, would be difficult to enforce. That is the point that we agree upon, I understand.
Well, I think one is impossible to imagine being enforced, and the other is feasible. So I think we have to break apart these things.
Right. Right. All right, so I would then propose that the walled gardens would be okay for not letting information get out. That's what you're saying?
Yes.
All right.
I mean, in principle.
In principle.
In many places, of course, data protection, in some sense, relies on this idea. Because the data controller is supposed to be able to have systems where they can send information from A to B or within binding corporate rules, precisely to achieve that objective. So if one, as it were, discounts the possibility of walled gardens, one should also discount the possibility of binding corporate rules, for example.
Well, I would say that if you are relying upon the controller to protect those gardens, then it's kind of out of national hands, because law is not always 100% effective. So you could have certain laws to force the controllers to act within state borders, but if it's up to the controllers, we're down to co-regulation rather than legal regulation. Would you agree? I'm thinking that...
I'm sorry. I'm noticing none of the students are engaging in the discussion, and I'm just wondering if any of you would like to jump in with your own.
I can move on to the other points, and we'll take that to lunch, won't we? Yeah, all right. All right, so then you said that the GNI is a failure, which I'm really sad to hear, because I thought that the Global Network Initiative would be a milestone when it comes to co-regulation. So the Global Network Initiative, at least from an academic point of view, would be the analysis that's needed out there. So you would be looking at the UN guidelines that you have for human rights and business being applied. So even if its practice is not satisfactory, as you had mentioned, I would say that the analysis that's being provided also by the members of the Oxford Internet Institute is the industry to be able to operate better. So I would, even if it's not working as feasibly as we might want it to be, I would say that at least from the research point of view, it is an achievement worth while. Now, just making, that's probably the most important part, just making a claim. I'm not saying that for the purpose of cyber attack attribution, we should build a more efficient way of identifying cyber attackers. That is not my claim. I'm just saying that right now, at the current state of affairs, it's not always possible, and it's often difficult to attribute. Right. Now, the most interesting question about privacy protection to me, and probably one of the reasons why I'm here, is exactly the question that you had mentioned. Where is the line? On one hand, you want to be protected from cyber attacks originating from foreign territories, and you want the states to do as much as they can to protect you from foreign attacks, right? And on the other hand, you want your privacy, and you want a global standard of privacy. I do not have an answer to that question, where that line can be drawn, but I agree with you that the debate, if we're speaking about cyber threats and cyber attacks, must include the level of possible privacy protection, of applicable privacy protection. So I'm 100% with you on that. So it is the reverse, the flip side of cybersecurity would be the question of privacy. Just one more. You proposed a bounty system for whistleblowers. And you emphasized that it might be difficult to enforce, and I agree with that. I would believe that there might be not enough political will on the side of the governments. How would those resources be found? Who would fuel that fund for those whistleblowers? That would not be in the interest of states. I don't know if it would be in the interest of companies, because it is often the companies that collaborate with states when it comes, albeit just arms trading, right? So I would have a problem imagining how that would work technically and where the money would come from, right?
The trouble is, I mean, if the US is behind Stuxnet, then clearly the US has taken the decision to develop aggressive cipher warfare capabilities. So the US is not going to be signing that treaty.
Well, there you go. And I would say the companies neither would be. So the states wouldn't do it, and the companies wouldn't do it.
Well, other states might be quite keen on it. And in fact, smaller states, I think it'd be a very rational thing for them to support.
Well, if it's a question of money, then how high would be the price for
Well, you
you know, to encourage?
And of course, you could recover the money from the state found to be infringing. So,
Well, it would have to adhere to the treaty then, right? And that would not be possible. So I like the idea. I think it's something that really might encourage a more open debate, like the WikiLeaks example has shown us. I think it would be difficult to enforce. And there's one more on the co-controller relationship relating to the YouTube case. Can we take that to lunch?
Sure.
Right? Because I think that we're just hitting on
We have
the end of our
We have
time.
time for one more question from the... Okay, well, let's have coffee, and let's be back at right at 11:30 to start with Lizzie Holtzkamp, who's in the library right now. Thank you so much.
Thank you so much.